Good afternoon. Attorney Protective would like to welcome you to today's webinar, PayPal, How to Ethically Bill Your Clients and Avoid Fee Disputes. Please reference your materials for information about today's speakers, Erik Crep and Erin McCartney. With that, I would like to introduce your first speaker, Erin.
Thanks so much, Kate, and welcome everyone. Thank you for joining us today to talk about the ethics of billing and avoiding fee disputes. I think most of us joining the webinar today would agree that no one likes dealing with bills. We don't like sending them. We certainly don't like getting them. And I know I especially don't like that uneasy feeling of opening a bill from a vendor when I'm not really sure what the price tag will be. I don't like that initial feeling of uncertainty, and either do clients when they receive their legal bills. Before we dive into the discussion on ethical and unethical billing practices, I think it's important to remember that when a client hires a lawyer, they're usually doing so out of necessity. So whether they're being sued and they need a really good defense team, or whether they're beginning the process of a tough divorce, whatever the representation entails, a lot of clients are coming to you in a vulnerable state. So they're willing to spend their money to get out of a bad situation or retain the best attorney that they can afford. Some lawyers are only too happy to oblige, billing clients for every minute worked and then some in some cases. But is it ethical to charge a client more than $1,000 an hour of legal advice if you're on a 3-hour flight traveling for client A, but while in flight you're working on an oral argument for client B? Can you charge 3 hours for travel to client A and also 3 hours of prep time to client B? Can 3 hours really add up to 6 hours of billing? These are some of the things that we'll be discussing today. Now, Erik and I have seen a lot of malpractice cases in the course of our profession in which lawyers found questionable ways to squeeze money out of clients. Some are legal, but maybe in that ethical gray area, but would most likely make a client's blood boil if they found out. And the economy is still struggling a bit, so we are seeing more clients slow paying their attorneys, needing payment plans, or not paying their legal bills at all. So learning some new skills around legal billing may help you face some of these challenges that we're seeing today. Our focus during the presentation is going to be on some best practices for ethically billing and getting your bills paid without getting sued. Now, we're going to provide you with some guidance on how to implement billing practices that can actually cultivate strong, positive attorney-client relationships. So looking at the agenda, we're going to talk about the model rules of professional conduct. We'll talk about intake procedures. We'll give you some billing tips. We'll give you some advice on how to avoid fee disputes. And we're also going to talk about the impact of AI on billing. So with that, I'll turn it over to Erik to begin our discussion with the ABA model rules on fees. Erik?
Erin, thank you. Kate, thank you as well. I'm going to start the presentation to talk about ABA Model Rule 1.5. Every state has similar, if not the same, rules with respect to 1.5, right? And the key is, as stated on the slide, an attorney shall not make an agreement for a charge or collect an unreasonable fee or an unreasonable amount for expenses. And we will get into some examples of what is reasonable or unreasonable, or what courts have said is reasonable and unreasonable. But there are factors or elements with respect to determining what is reasonable or is not reasonable. And one of the first factors, or the first factor, is the time and labor required, the novelty and difficulty of the issue, right? And the skill required to perform the services. So, for example, if you're either being a plaintiff attorney or defendants or whatever line of work, as an example, if you do antitrust work, right, federal court stuff versus automobile or slip and fall versus medical malpractice, all of those rates are different because obviously someone is not going to be able to reasonably charge a client, whether it's an insurance company or someone who's self-insured for an automobile accident, the same that they're going to charge a client that they're doing international federal court issues, right? Those are two different skill requirements where the fee needs to adjust depending upon what the novelty and the difficulty of the question. right? Number two is the likelihood, right, if apparent, right, that the acceptance of a particular employment will preclude other employment of the attorney, right? Not to get political, but let's say you are representing a politician on something. That may take up your time 7 days a week, a majority of the day, which means you may not have time to do other work for other clients. Number three is the customary charges in a locality for similar services, right? So for example, major metropolitan areas, New York City, Miami, Los Angeles, those are different than middle of America, small towns, right? Those are different fees and different charges in those localities. Number four is the amount involved and the results obtained, and we'll get into some of those. The time limitations imposed by a client, right? Is it a normal, you get a case at the beginning and you have the normal track for whatever court you're in with respect to getting the case to the end resolution? Or is it a rush around the clock, a rush appeal you're taking over, right? Those are different with respect to what the fee can be. Is there a trial in 3 weeks, or is there a potential trial in 2 years from now? The nature and the length of the relationship with the client is also important. And then the experience, reputation, and ability of the lawyer, right? The first-year lawyer who just got their bar license in September obviously does not charge the same rate as the 20 to 25 year experience board certified lawyer, right? So all of those factors are things that the court or the bar, if you have a bar issue, look into to determine whether or not the fee or the expenses are reasonable or not. And just a couple examples that have come up over the years, either through cases that I've handled or cases that Erin has handled and we've spoken about. And some of this stuff, now that we're out of COVID, right? And I think Erin spoke about traveling on a plane. But another example is miles reimbursement, right? Everyone should be doing, if you're traveling for work, it should be the IRS miles reimbursement rate, right? Your accountants will be able to help you with that. You can probably Google to see what it is. I believe it changes once or twice a year. So you have to make sure that you are charging that amount as an example, and also the correct mileage, right? What I use, and I think the best practice, is go by Google Maps, how many miles it is that you're traveling, right? You don't want to estimate up. You can estimate down if you want, but you don't want to be above it. And why do I say this? Because you never know when a client is going to challenge any type of expense. If things go wrong or sour with a client, you don't want them to say they charge me 50 miles when it's really only 25 miles, right? So things like that, it's more of a common sense, right? What would you want your lawyer to charge you for miles? I want to be charged what it really is, right? So a couple examples, right, of what the courts over the last couple of years have deemed to be an unreasonable fee, right? One example, and I forget which jurisdiction it is or it was in, but the one party needed to get a letter delivered to the court, right? And instead of hiring a courier service or overnighting it on FedEx, right, they sent a paralegal, right? And the paralegal billed $190 an hour to deliver the letter to the court, which was about 2 or 3 hours. And the judge said, that's not a reasonable expense, right? That's not a reasonable fee. You should have used a courier. You should have used FedEx or any other type of service. There was another case about an unreasonable bankruptcy case where there was a pro athlete involved, and the lawyer involved in the case proposed $2.6 million fee, right, for a case that lasted about 10 months. And the total hours on that case, when you do the math, was 7,200 hours over 10 months, which is 24 hours a day for 300 straight days, right? That is not reasonable, right? That is not what the bar rules or the ABA allowed, right? So the court reduced that fee from, I think, $2.6 million to 1.5, give or take, right? But things like that, you cannot overbill, especially in today's world, right, where everything is running through computers and it's not a person checking the bill, but it's software. You can't do it because you will get caught, right? And you also can't do something like most buildings, at least where I am and where our office is, if you want to come in on the weekend, they have to turn the air on, at least on Sundays. Well, you can't recharge that back to the client, right? That's not a reasonable expense. Another example, right, is I think this was out of Oklahoma. It involved a federal court case where an attorney charged more than 500 hours for a civil rights case that the judge deemed unreasonable because it was a simple, straightforward Fourth Amendment excessive force case, right? And the attorney billed 19 hours on that case for research on well-established issues in the case, and they included 49 entries of discussions with co-counsel, right? Something like that, the court, if you're going in front of the court for fees, they're going to strike it down, right? Because the court said that the lawyer's inexperience, right? A case can't be your basis for learning or educating yourself on an area of law, right? You're deemed to at least have the most basic, knowledge with respect to the area you're practicing in, right? So, there's tons of examples, but in some, right, I think in terms of 1.5, right, bill for only the work you do, right? Be very careful on expenses and costs and mileage, right? And don't overbill excessive amounts in connection with work that you should probably already know, right? That's really, I think, the key, right? So when we go to the next slide that talks about additional ABA model rules and fees, right? Double billing, right? And that's what Erin mentioned at the beginning with respect to double billing. You're on a plane, you're traveling to wherever for an event, right? You can't simultaneously bill your client for the travel to the event and then also bill for, a motion or doing other work on another case, right? You can only bill for one event at a time. Otherwise, you are subject to potential ethical complaints on your bar license from one of the clients. If you get audited, that would show up, and also, fee disputes with that client. So, bill padding, right? If something takes you 5 hours, you bill 5 hours. If something takes you 2 hours, you bill 2 hours, right? You can't over pad or overbill events. And that seems like common sense, right? But we're going to get into a little bit with respect to AI and how all this is impacting what you can and cannot do, and we'll talk about that at the very end, right? But you don't want to also round up, right? If it takes you 45 minutes, you have to bill 45 minutes. You can't upcharge it to an hour, right? And where I've seen people get into some issues or trouble is depositions, right? A lot of clients, especially if you have corporate clients, want to review the transcripts, right? So when they're reviewing the transcripts, they're saying the deposition lasted from 1 p.m. to 5 p.m., 4 hours. Well, they don't want to see a charge for having to attend a deposition of 6 hours when it's 4 hours, right? Especially with Zoom, and especially with how it is now where you're logging in and off of Zoom. So that's very important. Let's go to Model Rule 1.5b, retainer agreements, right? The scope, right? These agreements are preferred to be in writing, right? I think they always should be in writing, right? And it should be within a reasonable time after commencing the representation. In a perfect world, it should be before the representation, right? And it should include many things or everything that the client can or may be charged for, right? Including copies, medical records, subpoena fees, flights, hotels, costs, FedEx, miles. All of those should be set forth in the retainer agreement with the client, right? Because that is, it avoids potential fee disputes down the road with the client, right? So it should show the terms of the agreement, right? And how it's paid, whether it's hourly, contingent, flat fee, all of that should be part of the agreements. And you guys should update your agreements from time to time, right? I know a lot of people use very similar agreements and then change it, but they should be updated, right? Don't cut and paste and use one from 30 years ago, right? 20 years ago, times have changed, right? It takes 15 minutes to update your agreement, and that could prevent potential issues down the road, right? And the scope of the representation should be included, right? State the legal services, right? It eliminates confusion, right? It eliminates any potential issues down the road of, well, I thought you were representing me to do this as well, right? So if you're going to represent, for example, someone on an immigration matter, you're going to file the application, you're going to represent them at a hearing, right? You're going to go to court, but you're not going to do any type of appeal work. Put that in the retainer agreement. Say, this is what I'm going to do, but it's not including any appellate work, right? Make it clear so that everyone knows what your role is and what you're going to do on a case, right? Explain how you're charging, how you bill, your right to withdraw, right, under circumstances, the client's right to terminate. All of that stuff should be listed in your retainer agreement. Let's go to 1.5C for the plaintiff lawyers out there, your contingency fee agreements, right? These shall 100% must be in writing, right? And they must be signed by the client and shall state the method by which the fee is to be determined, right? A lot of times, most states have bar percentages, right? Pre-suit, what's the percentage depending on the money amount, after a lawsuit, before an answer, or if someone admits liability, like all of that, most bars, most states have guidance on that. So just make sure that is in there. But similar to the retainer agreement, right, make sure other expenses, litigation expenses, are also included on your contingency fee agreement, and the timing of when those fees are taken out, right? Who gets the money first, right? Usually, my experience, plaintiff lawyer takes their percentage, then the costs, and then the client gets the money. Make sure all of that is set forth in the agreement, right? And then so that the closing statement eventually, when the case is over, matches what is already signed and already agreed to by the client. Let's go to 1.5D, right? And this talks about various agreements that you cannot enter into, right? You cannot have a contingency case for domestic relations matters, right? For family matters, for divorce, for custody, right? You cannot also have contingency fee agreements if you do criminal work, right? It can't be, I'm going to charge X if I get a plea, I'll charge Y if you're acquitted, and if you're guilty, I charge Z, right? There has to be, it can't have that type of agreement. A division of fees between lawyers who are not part of the same firm, right? These must be in writing, right? These are the typical referral fees, right? And the client has to agree to these, right? In writing, right? There can't be any side deals, right? There can't be any, here's a case, shake my hand, give me money under the table. That's not allowed. The client must also agree to the referral and must sign off on it, and the total fee must be reasonable, right? And that goes back to 1.5A with respect to reasonable fee agreements, right? So just remember, these agreements need to be in writing, right? They need to be signed by the client, and they need to be reasonable. And I think a lot of times if you read through the rule, right, just don't get caught up in just trying to make the quick buck and jeopardize your license, jeopardize client relations or a lawsuit over something that is short-term gain, right? Always do what is proper, always do what is right pursuant to the ABA rules as well as your state's rules, and you should be fine. And it's all set forth. Most state bar associations, at least I know Florida, has all the rules available. There's even commentary on a lot of rules. But at the end of the day, a lot of it comes back to common sense with respect to billing. So with that, I'm going to pass it back to Erin, who's going to talk a little bit about the intake procedures.
Great. Thanks so much, Erik, and great job covering those rules. And really what the rules are about, clients don't want surprises, right, when it comes to their legal bills, but either do you. So this is really where the intake procedures are important. So let's look at intake procedures and more specifically how they can help avoid billing issues down the road. I think all too often attorneys want to practice law and not necessarily deal with the operational part of running a law firm. But your client intake process is often your client's first experience working with you and your staff. For your new clients, this intake process can either validate or invalidate their decision to work with you. So don't miss out on a great opportunity to improve your law firm's performance by doing a little bit of work on the intake process. It could yield some long-lasting benefits. So ask yourself, when a client comes into the office, what are the typical intake procedures of the firm, and are they working? I think taking time on the front end to do certain key things during new client screening and intake can give you more certainty that you'll be working for reliable clients and getting paid. So what are some of those key things? Have a standard potential client intake form with a template of questions that elicits the information you need for client screening. I am a big fan of using forms as a starting point for things like client intake or engagement and disengagement letters, as well as fee agreements. One size may not always fit all, but forms are a great place to start to be sure that key things aren't forgotten. Forms are also a great starting point for the client interview. The Florida Bar Association has a pretty good initial client consultation interview form on their website. This can be a great launching pad for the development or the refinement of your own. So let me just walk you through some of the things that it contains. It has this great lead-in paragraph about the purpose of the initial consultation. It says, the purpose of the initial consultation is for the attorney to advise you, the prospective client, what, if anything, may be done for you, and to assess what the minimum fee therefore will be. The purpose is not to render a definitive legal opinion, as it may be impossible to fully assess a matter within the time frame allotted for a consultation or with the information or documents that you may be able to provide at the initial consultation. It also advises one of three outcomes is possible following your consultation. 1, you and the attorney mutually agree to the terms of the representation. 2, the attorney declines representation. Or 3, you decide not to use the services of the attorney. These upfront explanations clearly set expectations out of the gate. I really like the section that says, knowing that there's no guarantees, what can you accept? These questions really get the potential client thinking about how they see this matter going forward. Another great question on the form asks, if the matter involves payment of money you feel you are owed, how long can you wait before not getting paid? This is an important one. If they write down, I need the money tomorrow because I'm flat broke, you should start seeing some red flags. Maybe they don't have money to pay their bills. Another great question is about prior representation on this matter. Don't you want to know if they were fired as a client by another attorney? I actually handled a case where I couldn't understand why this firm took the client. By the time the firm that I was defending was hired, the client had already been represented by 3 other law firms and had sued 2 of them. Not surprisingly, she decided she wasn't happy with my lawyer services either, and then ended up filing a malpractice suit against the firm and refused to pay any of the legal bills, which at that point had added up to a significant amount. Do you think the firm should have taken on this client? Should they have been surprised when she didn't pay any of her bills and then turned around and sued them for legal malpractice? Probably not. So keep in mind, it's a huge red flag when a client is changing lawyers in the middle of the case. And it's even a bigger red flag when they're suing their former lawyers for legal malpractice. They are either trying to avoid paying their legal bills, or they may be very difficult to satisfy. But either way, you may not want them as a client. So use this intake form to gather information to properly screen a potential client. And again, this Florida Bar Association form, I think it's really, really good. We have additional resources on our website at attorneyprotective.com under Protect Your Practice. So if you are looking for more resources, that's another place to look. Okay, so once you've reviewed the form, there should be a face-to-face interview. And then during that interview, you should learn more about your client's issues. Some you might be competent to handle, but others you may learn you're not. Remember that doctors send patients to other experts when something is outside their scope, and so should lawyers. This is also when you have to be honest with yourself and your current caseload. Do you have the time and resources to properly handle this matter? Make sure you know the rules of professional responsibility within your jurisdiction and the obligations that you have to your clients. Be mindful of your duties to the client, as well as the client's rights, such as the right to be promptly informed of all developments, and then make sure you can adhere to them before taking a case. If you are a small firm and you anticipate being inundated with documents, depositions, motions, should you take the case, you could miss deadlines, or you may not have time to communicate with the client, and this could result in the client refusing to pay their bill. They're angry, they feel neglected by you. So use your instincts when accepting a client. Take adequate time during the initial interview to develop a feeling as to whether the client will be a problem. Do they have unrealistic expectations? Are they cooperative? Does the potential client seem extremely disorganized? This can not only be extremely frustrating while representing them in their matter, but it may be a good sign that they're not going to pay their bill because it's either misplaced or accidentally thrown away, or they're so frazzled they've completely forgotten all about it. Another type of client that can be a potential problem when it comes to paying bills are those who are difficult to satisfy. If the potential client seems particularly nitpicky about things, well, there may be a very good chance that they're not going to be pleased when the representation comes to its conclusion, and they may use that as the reason for not paying their legal bill. You should try and make an assessment up front as to whether a client can afford your services, and there are several approaches to determining if a client can afford fees. Giving the client a reasonable estimate of fees and expenses, and then judging the potential client's reaction, this can help avoid problems. If your first reaction to discovering a billing problem with the client is, I knew the client was going to be trouble, or I knew I shouldn't have taken the case, you probably need to do a better job screening potential clients. So, in summary, some red flags that the client could burn you on billing would be changing lawyers in the middle of the case, trashing the lawyer they just left, reluctance to answer basic questions, providing inconsistent or incomplete information, and then wanting to use the legal system as a weapon of revenge or retribution. So be smart. Don't ignore these red flags or even that gut telling you not to take on a client. Remember, you do have the choice not to take a case. Okay, so let's move on to intake procedures, but more specifically letters. So after the initial interview and checklist, you decide to represent the client. Once you've decided you can and will accept them as a client, you'll need to translate your agreement into an engagement letter and a fee agreement. Obviously, the scope of an engagement letter is much broader than just fees, but for today's presentation, I'm just going to focus on the fee aspect. So you've already discussed the fees during the client intake process, so it should be pretty easy to reduce the understanding to writing. The agreement should be straightforward and understandable. If it was not clear and there wasn't a clear understanding about the fees and expenses up to this point, it should be clear now. Keep in mind that many disputes between lawyers and their clients are about money, and Erik and I can definitely attest to that in handling malpractice cases. So the engagement letter should set the attorney's fees, the associated costs, and how and when the client will pay straight. because if there is a dispute down the road, the agreement can assist in fee retention. A written contract forces both of the parties to be very clear about what they expect from each other. The engagement letter also can assist in managing risks arising from legal malpractice and disciplinary liabilities. In fact, I can tell you from handling legal malpractice claims, the engagement letter is the first thing that we ask for in defending a legal malpractice claim. So what should be in this engagement letter to ensure that you don't run into billing issues in the future? Well, you should specify the name of the client. It should include the fee arrangement and expectations for payments. How much money will it cost to achieve the intended result? If it's a contingency, you want to clarify what costs the clients will be expected to pay. If hourly, prepare the initial budget. And keep in mind that generalizations can get you in trouble. You also want to set forth a detailed scope of professional services to be provided, as well as services that the firm may not be providing. I've handled many legal malpractice claims, and a lot were filed simply to reduce legal fees. But when the bill is so general, it makes it more difficult to defend. I saw things like 50 hours spent on case X, Y, and Z at $400 an hour. You owe $20,000. Please pay immediately. The client deserves to know what you spent your time working on, and this is why itemized accounting is a good idea. Where exactly did those 50 hours go? If you claim you wrote a letter to opposing counsel for 4 hours and the letter turned out to be a paragraph long, your client has the right to seriously question your time management. So itemized accounting, it also helps keep you honest. Now, the engagement letter should also include any important dates and potential benchmarks, and it should outline the responsibilities of the attorney and the client. And I think this one is really important when it comes to avoiding potential billing issues. You need to explain the process. What is expected of your client as far as document production or depositions? Explain settlement versus trial, experts and other expenses. How long will it take until resolution? If you're upfront with the client about what is expected of them and what's expected of you, and you have it in writing, if there is a fee dispute at a later date, you have this agreement to hang your hat on. If the scope of the representation is questioned after the fact, you will be in a much better position to substantiate your version through this engagement letter. And this same principle, it applies to non-engagement and disengagement letters. When talking about engagement letters, I just thought it was quickly important to address non-engagement and disengagement letters too. I get asked a lot whether a firm should use or incorporate disengagement letters into their practice. First, I recommend that lawyers incorporate closing or disengagement letters into their practice to help clearly communicate that representation has concluded. And this is important because disengagement letters provide powerful evidence of the date the attorney-client relationship terminated. Essentially, closing letters transform current clients into former clients for the purposes of avoiding conflicts with other prospective clients. And the absence of a disengagement letter has contributed to the filing of legal malpractice claims by persons to whom the lawyer believed they no longer owed a duty. So a common legal malpractice scenario that I've seen is that without a disengagement letter, a client later alleges that the attorney failed to follow up on a case before the expiration of statute of limitations. So without a definite termination date, the statute of limitations for a malpractice claim can effectively cease to begin running. So I highly encourage you to use disengagement letters. And I would also use the disengagement letter as a way to actually reinforce the quality of your work and also to encourage clients to look for your firm for any future legal needs. It's also a great place to remind the client of the firm's document retention or destruction policy. So again, there's some great forms out there for these letters. They're available online. There's some on our website as well. But I just wanted to provide some sample engagement or disengagement and non-engagement letters here because on our risk management hotline, I get asked for templates for these letters all the time. So I just wanted to share them with everybody in the audience today. Okay, so moving on, let's talk about clearing the smoke and mirrors when it comes to intake procedures. On clearing the smoke and mirrors, I want you to stand in your client's shoes for a minute. As a consumer, we expect a level of certainty when it comes to our services or the products that we purchase. So whether it's a monthly credit card statement, a plumbing bill, or whatever other invoice I receive, I want an itemized list so I can see exactly what I'm being charged for and if the charges are legitimate. Your clients want this for their legal bills too. They want to understand how the expenses were generated. For example, if you're handling a case in another county, there may be additional expenses associated with that. Does your client understand that? This is why you want to provide itemized billing. We touched upon this a little earlier, but you want to make sure you're providing itemized billing and you're also reviewing them for errors. All associate bills should be reviewed by a partner before the client's billed. You want to look for errors such as double billing, like Erik talked about, charges on the wrong file, and also if the amount of time spent on a particular task is reasonable. You also want to avoid vague billing descriptions. Complete, detailed, and accurate task descriptions are the easiest way to prevent a client from flagging your bill. Every task description should identify the activity with sufficient detail to assess its necessity and the relevance to the project. Along with a detailed description of the task, each time entry should include the date the task was performed, the timekeeper who performed it, and the time spent performing the task and the total fee. Your client may question why you billed 45 hours reviewing and revising a brief. Perhaps the brief was really long. It involved multiple and complex issues and extensive research. Whatever the reason, vague terms like review and revision, they do little to inform the client why the review merited a week's worth of time. Simply giving clients hourly rates, it doesn't really give them the full impact of the cost of the services, especially in more complicated matters. So estimating the full cost of the representation, it helps clients understand how expensive the matter may be. And you want to make it clear that you must get paid regardless of the outcome. And clients who are fully informed about costs and risks are less likely to complain about fees. Erik talked about this too, but all fee arrangements should be in writing. Combining fee agreements with engagement letters specifying the work to be done, it's a very efficient way to ensure that the communications about fees are in writing. And then keep in mind that a well-informed client is likely to pay their bills. So you want to routinely connect with your client. You want to bill at regular intervals. You want to return calls promptly, or even provide office hours. This would be providing times when you can make yourself available for client calls. And then keep your client informed of any changes in evaluation, and you want to put that in writing as well. Did your evaluation change due to an expert report? Did a client or opposing party perform better or worse at a deposition? Did a witness come forward? Anything like that that changes the budget, you want to advise the client as soon as possible. Communication with the client, it's not something that lawyers should just consider at the beginning of the representation, but really throughout the life of the case. And as the case progresses, you want to discuss any developments which either increase costs or decrease the likelihood of success shortly after they occur. And then provide the client with new estimates of costs in writing as the case continues. The bottom line is you just want to take any guessing on the client's part out of the billing equation. Okay, so next, let's talk about withdrawal for non-payment. This is another question I get asked a lot about. Can a lawyer withdraw from representing a client for failure to pay their legal bills? The general rule is that a lawyer may withdraw from representation when a client refuses to pay the attorney for services in violation of the fee agreement, or if the representation causes the lawyer financial hardship. This general rule holds so long as the withdrawal is not materially adverse to the client's interest. Now, despite best efforts, some clients may still not pay their legal bill. Some precautions to help mitigate the risk of non-payment include using adequate retainers and flat fees since you take the money up front. The fee agreement should set clear expectations for payment and the consequences for the client's late payment or their failure to pay. Will work stop until the account is current? Will the client be charged interest? State in your retainer agreement that non-payment is grounds for withdrawal. Utilizing these types of provisions in the fee agreement can help avoid situations in which you're contemplating withdrawal for non-payment of fees. You'll see some best practice tips here on this slide too regarding withdrawal for failure to pay legal bills. I think the two most important things under the best practices are Keep in mind that non-payment is not a defense to non-performance in a legal malpractice action. So a lawyer seeking to withdraw for non-payment should take reasonable steps to provide sufficient notice to the client so that substitute counsel can address any pending motions or prepare for trial if you're at that stage. Okay, so moving on to the next slide, let's talk about some billing tips here. So I have 7 billing tips listed. Number 1, and I think the most important one, is happy clients don't sue, and they generally don't complain about the bill. Believe it or not, there are plenty of clients out there who are thrilled with their lawyers despite them not having gotten the best possible outcome for their case. So you might be saying, well, how is that possible? It comes down to a positive client journey. Once you start adopting the mentality that each stage of the client journey is an opportunity to delight, you start transforming the way you run your practice. Where many lawyers fail to delight, I would say, is with client communication. And I have seen this time and time again. Keep in mind, if you fail to return repeated phone calls or emails, you might not get paid, but you also may be violating your ethical responsibility of communication. If you are busy working on another case because of an impending trial, or even if you're tending to a sick relative, let the client know this. Most clients will understand and they'll actually appreciate the honesty, but it's about setting expectations so the client isn't feeling neglected or forgotten. I think developing a strong client relationship can really pay off too in the long run. So this might mean, hey, you have to listen at least as much as you talk. Do simple things like ask open-ended questions. Find out how the client wants to get information from you. You can say, this is typically how often I will report. Does this work for you? What form of communication and reporting would you like? Let them feel that they have some control and are part of the process. I think that's really important. And again, it's about setting expectations. Clients may feel that something is really important and maybe it's not that important, but having them understand that and having them understand how often you will report, I think it will help in not only saving you time, but certainly it'll help with the client feeling like they're having a positive client-attorney relationship with your firm. Okay, so sticker shock. If there is going to be a big bill or any other negative news, don't let the client hear from the mail carrier first. Communication is the key to invoicing success. And we're going to talk about client communication in just a bit in a little bit more detail when it comes to managing the client relationship. But if you've noticed that your invoice in a billing period will be way off course from your client's expectations, don't ambush them with a terrifying invoice. Pick up the phone, call them, let your point of contact know exactly what's going on. Deliver the news concisely, clarify the who, what, when, why, how, and then add that explanation to the invoice after you have that conversation so they don't have to try to remember that you had already called them on the phone. And let your point of contact know what's coming ahead of time. Also, make the bill easy for them to pay. Possibly offer online payment solutions. Online payments offer the client more options to pay, making it more convenient for them to pay you. There was actually a recent study that I read, and it showed that law firms are getting paid almost 40% faster by using online payment solutions. So just something to think about. But your bottom line can only stand to benefit from making your bill easier for your clients to pay. Okay, so next, it never hurts to include a personal touch like a handwritten note or client newsletter with the bill. Mail your client's birthday or greeting cards, holiday cards. I read once that the effect a personal gesture has is usually proportionate to the effort it takes to make it. And I really think that's so true. It takes time to sit down and write a personal message, but I think the gesture is usually really remembered and appreciated, especially today. I think when less and less firms are doing things like that, I think it's a really good way to stand out and be remembered. Okay, next, bill immediately when you achieve a major milestone. Tie items billed to clients' hope for results. Billing immediately when you've just achieved a major milestone in a case, it makes perfect sense. You've probably heard the phrase, striking while the iron's hot. Well, usually achieving a major milestone is expensive. So celebrate the success with them, then send the bill before the euphoria is over. And then I would also include the client's recent or previous payment on this invoice. I think that's actually a really good form of positive reinforcement. So just something else to think about. I think it's inevitable that there will be inefficiencies on a bill from time to time. Disclose inefficiencies and write them off a bill. I know when retailers write something off, I kind of feel like I won something. I think an unseen discount, it's kind of worthless to your client. It's worthless to you. Even worse, bringing up a discount after the fact is far more likely to create resentment. So make sure you're getting some client brownie points when they're deserved by writing off some of those inefficiencies. And then make sure you tie build time to the client's hope for results. I think this sends a huge message, a huge positive message, that you listened to what they wanted and you did what they asked. Okay, so last, having the tough conversation, why aren't you paying the bill? Most risk management experts will tell you that it's a bad idea to work for a client for months without getting paid. I think common sense tells us this too, but more and more lawyers are doing this today, often driven by an optimistic or possibly an unrealistic belief that clients will eventually pay them. Or maybe it's driven by fear of having no clients waiting in the wings to replace that business. So what do you do when a client's not paying their bill? Don't just keep sending emails. Pick up the phone and call them. I think the lawyer is often the best person to call, not just the billing clerk or the bookkeeper. So think about getting the attorneys involved when a client stops paying their bill. As their lawyer, you or the lawyer involved, they already have a relationship with the client and hopefully talk to them on a regular basis. So if you're getting pushback from lawyers in your firm about helping out with receivables, maybe explain how better collections mean higher profit margins and more money without having to work additional hours or raise rates. And if necessary and possible, talk to the client about payment arrangement details. You know, on one hand, you probably don't want to advertise payment arrangements as it may encourage clients to pay late or pay less. But on the other hand, it's something that can be used to encourage delinquent clients to pay versus dealing with write-offs or write-downs. And then if a client's not paying you, there's usually three reasons why. One, they either have no intention of paying you, and therefore they're going to use all means they have to avoid paying you. Two, the cost of the representation may be more than they originally anticipated, and they're having a difficult time making that full payment. This is actually the best case scenario. They may be embarrassed, so they're avoiding you. But if this is the case, reach out, try to put together a reasonable payment schedule. The third reason is they're mad. They're either unhappy with the progress of the case, they're dissatisfied with your work or your billing practices, and they're angry about the lack of communication, and not paying you is one way that they're going to send you that message. So the client may refuse to pay for all or part of the work, or at the very least investigate the matter further, determine if it was justified. And I think taking a step back, many clients are nervous about working with attorneys. Legal bills can exceed most other expenses. I mean, they can even exceed the expense of a car. So clients may be confused about whether certain things are itemized or concerned about inflated bills, especially given what Erik had talked about with some of those cases that made headline news. So they might have this fear that they're going to be cheated somehow. But I'll say once they flag a bill, they will probably go through each one after that with a fine-tooth comb. So I think it's really important to take all of the things I just discussed into consideration in order for them to feel like they can trust their attorney and not feel that there's any surprises when they do receive that legal bill in the mail. All right, Erik, is there anything you want to add regarding billing tips before we jump into our discussion about avoiding fee disputes?
Yes, Erin, thank you. And I think I want to go back a little bit further when you spoke about clearing the smoke and mirrors. And I think it was touched upon by you in terms of budgeting in the beginning, right? I think it's very important to have a discussion and put it in writing, right? If possible, that's the gold standard way, to a client of how much the case will cost, right? What's the budget of it? What are the potential expenses? And there should be a range, right? And then to also add to what you talked about in terms of keeping the client updated, right? I think it's very important to let the client know when good things happen in a case and when unfortunate or bad things happen, right? The good things is obvious, right? You want your client to know and understand why they are hiring you and you're doing a great job. But as Erin said, you also want to let them know when something unexpected happens, or maybe it's expected and you anticipated it and it actually did happen. Whether it's a witness who gives a version of the events that is not supportive of your client, or the court gives a ruling that you don't agree with, that's important to let your client know as it happens. So as Erin said, at the end of the case, they don't get this bill with bad results, right? And then the last thing before I get into the next topic in terms of writing off examples, Erin talked about taking some fees off of your bill. I think that is a great idea. I think the best opportunity to do that is when clients call you, right? Because a lot of times clients are calling you for an update, and it may take 5 minutes to update them, but then you're also talking to your client about other things, right? You don't want your client to be afraid to call their lawyer because you're going to charge them for a 15-minute call when only 3 or 4 minutes are about the case. So put it on the bill and write it off, and the client sees it and then always want to talk to you, always want to give you information, always want to provide the information and not hide it from you, or not be willing to discuss the case with you because they don't want to get charged. So with that, let's quickly go to the last couple slides in terms of suing for fees and having fee disputes. Erin said it, and this is probably the case in 80% of the claims that I handle, right, is that it always starts with the law firm suing the client for past bills, right? 80% of the time that leads to a counterclaim, right? That always happens, so you have to analyze, is this something worthwhile? Can we work it out? Do we want to sue for money? Because the majority of the time that results in the client having some type of legal malpractice claim against you. Then there's cost of suing a client, right? Other than you potentially getting sued and never getting the money, right? There's an open claim against you, right? Or your firm. There's years of litigation. There's a deposition of you and maybe others in your firm. Public records search, a lawsuit being filed by anyone to see if it's a new client or someone else with respect to wanting to retain you, right? You definitely lost the client, and then depending upon the case and the circumstances, there could be negative press, right? So there's a cost of suing for fees that goes beyond just you suing your client. And all of that, I think, has to be thought about and analyzed on a case-by-case basis with respect to whether or not you actually want to sue a client. Managing receivables, right? Erin touched on a little bit. Don't let it get too out of hand, right? You should be following up with your clients. As Erin said, a lot of times they miss it. They're embarrassed, right? They want to pay the bill. They want to satisfy their obligation. So don't be afraid to call them, right? To talk to them. Because a lot of times when they get a call from the lawyer, right, whether it's a client, you're doing defense work in-house, a corporate client, and you call them, they're like, oh, I didn't see it, or we're behind, I'll get right to it, and it gets paid, right? So keep the lines of communication open with respect to managing receivables, right? Because I'm telling you, a majority of the time, they want to pay because they want to do what's right and pay. In terms of managing receivables, you can think about early payment discounts, right? I've seen some firms and some clients mandate the early payment discounts, right? If they pay within 30 days, 2% gets, it's 2% less, right? If they pay within 30 days, right? Or whatever the number is, right? Similar to a credit card fee. So think about adding that to your potential deals with your client in terms of payment. The next slide, avoiding fee disputes, right? Pay attention to the warning signs, right? If they're not returning your calls, if they're ignoring emails, if they're not cooperating with the case, if they're questioning you, like, well, why are we filing this motion, right? Why are we doing X on the case, right? If they're rude to you, things like that. But that's why I think it's key, as we've been discussing, the open lines of communication, right? If checks bounce, obviously that's a warning sign, right? If they need multiple extensions to pay invoices, that's a warning sign. but there's others as well. So just pay attention to them, follow your instincts, but communication is the key. And with that, I'm going to pass it back to Erin with one of the last topics of client communication.
Great. Thanks so much, Erik. So we did talk a lot about the importance of good client communication. You'll see some bullets there on your slide. But with the last few minutes, I did want to talk about the impact of AI on billing. This is such a hot topic right now. We're actually doing a full CLE on AI and how it's affecting law firms. So if you're interested in that, in a few months we're doing a whole CLE on that. Right now I'm just going to talk about the billing aspect and the impact of AI on legal billing. The intersection of artificial intelligence and legal billing, it is just one of the many issues that our profession faces when it comes to ethically integrating AI into our practice. I think as more and more firms are turning to AI to increase efficiencies in delivering legal services, an increased need for billing transparency is absolutely necessary. In July of 2024, the ABA actually issued its first formal opinion. This was Formal Opinion 512 regarding the use of AI in the practice of law. And it specifically addressed Model Rule 1.5, which Erik discussed at the beginning of the presentation. The opinion states, if a lawyer uses an AI tool to draft a pleading and spends 15 minutes inputting information into the platform, subject to their client's agreement and adherence to confidentiality constraints, of course, they may charge for that time plus the time necessary to review the draft. So be mindful of the time actually spent on a task, as padding your time is a clear breach of your ethical duties to provide a reasonable and accurate bill for your fees. So the time you spend on a particular task should be adjusted to accurately reflect the use of AI. So in other words, if a legal memorandum on an issue in your case was produced within mere seconds, subject, of course, to your careful review and confirmation that none of the case citations were hallucinated by the bot, you cannot charge the client 2 or 3 hours that it would have otherwise taken you to research the topic and draft the memo without the use of AI. So this is really important because Erik talked about bill padding earlier, and this is definitely where we see some lawyers getting into trouble. If you use AI and it is saving you time on your work, you can't say, well, without the use of AI, it would have taken me this long. This is what I'm going to bill the client. By leveraging AI, an individual client may benefit from the cost efficiencies in their legal bill, but lawyers will gain the invaluable gift of time to dedicate to additional files, or they can obviously use that time to work on other things that would not be assisted by AI. So this is something that we're going to see more and more of, but keep in mind that you cannot bill for time it would have taken you if not for the use of AI. And really, this should be in your engagement letters. This should be addressed as far as any impact on fees or costs that AI would have. And I think Erik and I were talking earlier. I think, Erik, you said your firm does have something in their engagement letter related to AI. Is that correct?
Yes, that is. And actually, we reference a Florida bar ethics opinion. It's 24-1. And in our initial letter on cases to clients, we discuss AI, we reference the opinion, we give them a copy of the opinion. And I think with respect to billing, because there's a couple more things in the Florida bar ethics opinion 24-1, but with respect to billing, it specifically says use of AI does not permit a lawyer to engage in the improper billing practices such as double billing, right? So using AI, it's beneficial, right? As long as you're checking it and it's not creating, sites that we all see on the news or whatever that don't exist. But you can't, like Erin said, charge 3 hours for something that AI did in a half an hour. So this is something that we send out on all of our cases to clients in addition to the statement of client rights, right, as well as this one. So I think it's very important that everyone look to see what their bars have on AI. I'm pretty sure most of them have formal opinions or are developing them, but I know Florida does, and it's Florida Opinion 24-1.
Great. Thanks, Erik. And I know we're just at that 60-minute mark, so I am going to open it up to Q&A. But before I do that, you'll just see there's a sample collection letter in your presentation materials. If you find yourself in a position where you need it, this is from the Florida Bar. This is just something else I get asked a lot about. But hopefully with client screening, staying on top of your bills, with good client communication, you will not need this. And with that, Kate, I'm going to toss it back over to you to open up our Q&A.
Great. Thanks so much, Erin. And thanks, Erik. Really great presentation today. So we have a lot of great questions coming in. First, is an engagement letter the same as a retainer agreement, or what is the difference?
Yeah, this is actually a great question. And Erik, I can take this because an engagement letter and a retainer agreement are often used interchangeably. And I probably did this in the presentation today, so that's why I'll jump on this question. So both function as a contract, right? A retainer agreement, it technically focuses on like the upfront payment to secure services, whereas an engagement letter, it's going to cover the broader terms of the representation. So both are legally binding contracts, and they're drafted at the beginning of the professional relationship. And I guess the best way to differentiate it is the engagement letter is going to focus more heavily on defining the scope of the services, and then the retainer agreement specifically addresses the retainer, or an upfront fee paid to secure the services, and then how that money will be held, used, and replenished. So in many law practices, the engagement letter is the retainer agreement, and they'll just combine the scope of the work and the payment terms into one document.
Okay, great. What about if I'm withdrawing for a lack of payment? What do I put in a motion to withdraw?
Yeah, I can take this one too, because I think I touched upon this in the presentation. Well, you want to state the legal basis for it, right? So you want to state the client's breached the fee agreement, and that continuing representation would pose an unreasonable financial burden on the attorney. You want to indicate that the client has been warned in writing and has been given reasonable notice to pay or to secure new counsel. You want to also affirm that you either have or you will take steps to protect the client, including providing them with their file, turning over any deadlines that are imminent, and then refunding unearned fees. You also want to avoid disclosing any specific intimate details of the fee dispute in a public motion. And then the most important thing really is just make sure you're adhering to your local rules. So you want to look up what the jurisdictional requirements are and make sure you're adhering to them in your specific jurisdiction.
Since we're over the hour mark, we'll just take one more question. Is writing a memo to the file considered billable time, and can I include that on a bill?
Erin, if you don't mind, I'll take this one. Yes. Right, because I think when you do a memo or notes regarding an event, it's similar to if you have to do a report to the client, right? So at least when I am doing reports to the client, right, those are certainly billable when I am summarizing or doing my thoughts on a case, my defense plan. And I think the same is with respect to notes and memorandum, because you are documenting in the file for your client and for yourself, right, what event happened, what your thoughts are, what your strategy or strategies are. And that is certainly billable, and I would recommend that people share this with your clients so your clients are always aware of what you are thinking and what the plan is. And that goes back to the continued communication with your clients, right? If you attend a deposition, whether you call it a memo, a note, a report letter, all of that stuff, all of those events are billable and should be shared with your client, so your client is involved and knows what's going on, and you continue to clear the smoke on a case, and they're not surprised at the end if it doesn't go the way that they think it should go. So bottom line, I guess the answer to that question is yes. If you are doing notes or memorandum, you are allowed to bill for those events.
Thanks, Erik. That's helpful advice. I would also like to thank our speakers, Erik and Erin. Thanks so much. Have a great day.